Hello everyone, as you all are aware that we are daily posting videos on important case related MCQs. In furtherance of that, in this video, we will discuss case related MCQs of contract. So the first question is, which judicial pronouncement of the Queen's Bench of England had dealt with the concept of general offer? The correct answer is A. Carlyle versus Carbolic Smokeball Company. Question number 2. Union of India versus Madala Tathaiya is an illustration where the tender was in the form of standing offer. Which one is the famous case related to the general offer? Correct answer is Carlyle versus Carbolic Smokeball Company. It's a case related to general offer. Which one of the following is a leading case on the point of communication of offer? Correct answer is Lalman Shukla versus Gauri Datta. In Carlyle versus Carbolic Smokeball Company, the court ruled A. that an offer made to public at large is nudum pactum. B. that a general offer is no offer. C. that an offer can be made only to a particular person. D. an offer need not to be made to an ascertained person. The correct answer for this is D. An offer need not to be made to an ascertained person. Which of the following case is related to the cross offer? Correct answer is B. Tin versus Hoffman and Company. Question number 7. In case of general offer, there is no need to communicate the acceptance if not required by the proposer. This has been held in A. Carlyle versus Carbolic Smokeball Company. In which of the following cases, which case relates to general offer? Correct answer is Lalman Shukla versus Gauri Datta, Carlyle versus Carbolic Smokeball Company. They both cases related to the general offers. Generally offered to world at large does not make it necessary on the part of the acceptor to communicate his acceptance. This is well explained in Carlyle versus Carbolic Smokeball Company. An offer need not to be made to all the world, which is to ripen into a contract with anybody who comes forward and performs the condition. It is an offer to become liable to anyone who, before it is retracted, performs the condition, and although the offer is made to the world, the contract is made with that limited portion of the public who come forward and perform the condition on faith of the advertisement. Above statement is attributed to Lord Justice Bowen in Carlyle versus Carbolic Smokeball Company. Match the following. Match list 1 and list 2. List 1 says A. Proposal, B. Invitation to make an offer, C. Communication of acceptance of offer by acceptor himself, D. Revocation of offer. The correct match of list 1 and list 2 is A. Proposal. This is related to Maharashtra Rajya Sarkari Kapas Utpadak Pranan Mahasabha Limited versus Mangbhanga Chaudhary. A. Proposal. Invitation to make an offer. This is related to Granger and Son versus Gog. C. Communication of acceptance of offer by acceptor himself. Correct answer is Powell versus Lee. D. Revocation of offer. Here the correct answer is Hanthorne versus Fraser. Match list 1 and list 2. Again, list 1 says A. Lapse of offer, B. General offer, C. Communication of proposal, and D. Implied proposal. Here the correct match will be A. Lapse of offer. Correct answer is Hawthorne versus Fraser. General offer, B. Correct answer for B is Week versus Tablet. Communication of proposal. The correct answer is Coffee Board versus CCT. Implied proposal. The correct answer is Lalman Shukla versus Gauri Datta. The leading case of Carlyle versus Carbolic Smokeball Company is related to general offer. A's nephew has absconded from his home. He sent his servant to trace his missing nephew. When the servant had left, A then announced that anybody who discovered the missing boy would be rewarded. When the servant came to know about the reward, he brought an action against A to recover the same. But his action failed. It was held that the servant was not entitled to the reward because he did not know about the offer when he discovered the missing boy. Name the case on reading the facts. Correct answer is Lalman Shukla versus Gauri Datta. These were the facts of this case, Lalman Shukla versus Gauri Datta. List 1 and list 2. Case and principle. List 1 case Lalman Shukla versus Gauri Datta, B. Macpherson versus Apanna, C. Banwari Lal versus Sudarshan Das, D. Anthony Chaku versus State of Travancore. Correct answer will be Lalman Shukla versus Gauri Datta, general offer. Macpherson versus Apanna, the correct answer is invitation to treat. Banwari Lal versus Sudarshan Dayal. Correct answer is intention to create legal relationship. And MC Chako versus State of Travancore. Correct answer is privity of contract. Match list 1 and list 2. Carlyle versus list 1 says A. Carlyle versus Carbolic Smokeball Company. B. Fisher versus Bell. C. Tin versus Hoffman and Company. And D. Harvey versus Facey. The correct answer will be Carlyle versus Carbolic Smokeball and Company. It will be offer at large. Fisher versus Bell. The correct answer is invitation to treat. Tin versus Hoffman and Company. Correct answer is cross offer. And Harvey versus Facey, as we have already discussed, this is quotation of price. List 1, match the following: Balfour versus Balfour, Oxford versus Davis, Dunlop versus Higgins, and Hyde versus Rich. The correct answer for this is Balfour versus Balfour. Correct answer is revocation. Balfour versus Balfour. Correct answer is intention to create legal obligation. Balfour versus Balfour, intention to create legal obligation. And Oxford versus Davis. The correct answer is revocation of offer. In Dunlop versus Higgins, correct answer is acceptance through post. And Hyde versus Rich, correct answer is counter offer. In which of the following cases the court rendered decision on public offer? Correct answer is Securities Exchange Board of India versus Akshaya Infrastructure Private Limited. Bank of India versus O.P. Swarnkar AIR 2003 Supreme Court 858 is an important judgment on the following issue. Correct answer is invitation to offer. An offer cannot be accepted unless and until it has been brought to the knowledge of the person to whom it is made. It was held in B. Lalman Shukla versus Gauri Datta. We have already discussed the fact of this case. Which of the following is incorrectly matched? Correct answer is Feldhaus versus Bentley communication of offer. This is incorrectly matched. So these are not correctly matched. But if we see the option 2, Samuel versus Anantnath, privity of consideration, Lowy versus Pierce, agreement and restraint of marriage, Taylor versus Caldwell, destruction in subject matter. B, C and D are correctly matched. But the question here asked is incorrectly. So the correct answer will be A. Acceptance. In which of the following cases it was held that a contract through telephone is concluded at a place where the acceptance is heard? Correct answer is Bhagwan Das, Govardhan Das, Kedia versus Mezersons, Girdhari Lal, Purushottam Das and Company. Consider the following statements. In Bhagwan Das, Govardhan Das, Kedia versus Girdhari Lal, Purushottam Das and Company, it was laid down that first, Section 4 does not imply that the contract is made qua the proposer at one place and qua the acceptor at another place. Second, the communication of acceptance should be from a person who has the authority to accept. Information received from an unauthorized person is ineffective. Which of the following statement is correct? Only one is correct, which says that Section 4 does not imply that a contract is made qua to the proposer at one place and qua the acceptor at another place. For an acceptance, mere mental resolve to accept would not be sufficient. There must be some external manifestation of the intent by speech, writing or other act. Correct answer is Bhagwan Das versus Girdhari Lal and Company. The rule laid down in Adam versus Lindswell was approved by the House of Lords in Dunlop versus Higgins. A contract over a telephone becomes complete at a place where the acceptance is heard. In which case it has been laid down? Bhagwan Das versus Girdhari Lal. Which of the following case it was held that a contract through telephone is concluded at a place where the acceptance is heard? Correct answer is Bhagwan Das versus Girdhari Lal. Consider the following statement. In Bhagwan Das, Girdhari Lal, Kedia versus Girdhari Lal, Purushottam Das and Company, it was laid down that Statement 1. Section 4 of the Indian Contract Act 1872 does not imply that a contract is made qua the proposer at one place and qua the acceptor at another place. Second statement, the communication of acceptance should be from a person who has the authority to accept. Information received from an unauthorized person is ineffective. Which of the statements are correct? Only one is correct. We have already discussed this question. When a contract is made on telephone, it becomes complete at a place where the acceptance is heard. In which of the following it was held? Bhagwan Das versus Girdhari Lal. match. Acceptance, list 1, A acceptance, B crossover, C minus contract, and D res. Here the correct match is A acceptance. This is acceptance must be communicated. A crossover, no contract concluded. Minus contract is void ab initio. Res extincta, courtier versus hasty. Again, list 1 is case and list 2 is rule laid down. So the list of cases are A. Ramsgate Victoria Hotel Company versus Montiflora, B. Tin versus Hoffman, C. Household Fire Insurance Company versus Grant, and D. Fitch versus Snedeker. Correct match will be Ramsgate Victoria and Hotel Company and Montiflora. Correct answer is 4. Unreasonable delay in accepting offer causes it to lapse. In B. Tin versus Hoffman. Correct answer is crossover do not create contract. Household Fire Insurance Company versus Grant. Here the correct answer is acceptance complete when the letter of acceptance complete when the letter of acceptance is posted. Fifth versus Snedeker. Here the correct answer is communication of offer cannot be waived. In the case of a contract, the information received from an unauthorized person is ineffective was formed in B. Powell versus Lee. In which of the following cases the Supreme Court held that in order to create a contract, acceptance of an offer and intimation of acceptance by some external manifestation which the law regard sufficient is necessary. Here the correct answer is Bhagwan Das versus Girdhari Lal and Company. Here we will wind up this video. In next video we will proceed forward by discussing the second part of this section, that is case laws MCQ of contract law. Thank you, and please subscribe us and forward this video to those who are preparing for judicial services or various examination in which contract law is asked. There is also a separate playlist we have made of case laws MCQ. If you haven't seen that, please go to our main video section. You will find that playlist over there. Thank you for watching. Thank you so much.